Picking up in Chapter 2 about attorney's fees, in the California Civil Procedure Handbook, Rules, Selected Statutes and Cases, and Comparative Analysis by Heiser, published by LexisNexis 2007, I finished reading the majority opinion of a case involving Daimler Chrysler. It was a class action, so it was Graham. And there's a dissenting opinion after the majority opinion, starting with Justice Chin. I dissent. Plaintiffs filed a simple 7-page complaint alleging a single cause of action for breach of warranty after the defendant had already acknowledged its marketing mistake and was taking steps to correct it. And while the Santa Cruz County District Attorney and the California Attorney General were investigating the matter and preparing to take appropriate action, the complaint constituted plaintiffs' entire legal effort regarding the underlying lawsuit. They obtained no judicial ruling of any kind in their favor. Nevertheless, to date, plaintiffs have parlayed this complaint into an award of attorney fees of $762,000, most of it for work unrelated to the underlying lawsuit. Now the majority remands the matter for yet more litigation. I disagree for several reasons. This court was never awarded attorney fees to a party with no judicial ruling in its favor. We should not start now, relying solely on federal cases that have been overruled and California cases that either denied attorney fees or involved the plaintiff with a judicial ruling in its favor. The majority permits an award of attorney's fees to the plaintiffs as the prevailing or successful party. To do so, it adopts the so-called catalyst theory, a theory that was once prevalent in federal courts, but that the United States Supreme Court has now repudiated. We should not resurrect it. Moreover, plaintiffs do not qualify for attorney's fees even under the majority's catalyst theory. Their lawsuit was unnecessary when filed. It was moot within days of its filing, and it conferred no substantial public benefit. Plaintiffs have also failed to show their suit had any merit in light of the corrective steps defendant has already taken. The majority implicitly recognizes that plaintiffs failed to justify their award of attorney's fees, but it inexplicably remands the matter yet for more litigation, which will undoubtedly increase plaintiffs' attorney fee demand to a truly astronomical amount. I disagree here also. No reason appears to give plaintiffs a second chance to try to prove what they failed to prove the first time. Courts should seek to resolve litigation, not perpetuate it. Finally, the majority permits qualifying plaintiffs to receive not only 1, attorney's fees for litigating the underlying lawsuit, but 2, a multiplier on those fees, and also 3, attorney's fees for litigating their entitlement to attorney's fees, and also 4, a multiplier on the fees for litigating entitlement to fees. I disagree on the final point. Surely, awarding fees for the underlying litigation with a potential multiplier plus fees for litigating entitlement to fees is sufficient. A multiplier for litigating fees on fees is excessive and can only lead to outrageously inflated awards like the one here, where a simple complaint is transformed into an award of over $750,000. The majority today goes further than this court has ever gone before, indeed, so far as I can tell, further than any other court has ever gone, in permitting plaintiffs to win large attorney fees awards. I cannot agree. Lest California truly become a mecca for plaintiffs and plaintiffs' attorneys throughout the country, we need to be at least somewhat in step with the rest of the country. Discussion. A. California should not adopt the catalyst theory. California follows what is commonly referred to as the American rule, which provides that each party to a lawsuit must ordinarily pay his own attorney's fees, citations omitted. The legislature codified the American rule in 1872 when it enacted the Code of Civil Procedure Section 1021, which states in pertinent part that, except as attorney's fees are specifically provided for by statute, the measure and mode of compensation of attorneys and counselors at law is left to the agreement express or implied of the parties. Trove v. Katz of 1995. Code of Civil Procedure Section 1021.5, enacted in 1977, provides an exception to this American rule. In Buchanan, I don't know where I stopped recording, but I'm in the middle of the dissent opinion. The majority are... when did I turn the page? Let's start at the beginning of page 37. A judicial imprimatur on a defendant's change in conduct It is thus necessary to show that the plaintiff actually enforced a legal right. Merely eliciting a voluntary action is not enforcing a legal right. But the catalyst theory simply assumes the defendant's action was required to right a legal wrong. It assumes the defendant had acted unlawfully. This assumption is contrary to the requirements of the Code of Civil Procedure, Section 1021.5. The majority argues the catalyst theory is needed to eliminate risk in public interest litigation, but there will always be risk. I'm not going to go more into that. It's about line drawing. The potential for awards of this kind can also greatly increase the possibility of undue pressure to settle meritless claims. Indeed, the private attorney general doctrine, even without the catalyst theory and multipliers on fees, gives the plaintiffs a great advantage in settlement negotiations. The defendants generally have to pay their own attorney's fees. Thus, those defendants who litigate rather than sell out as cheaply as possible, as soon as possible, face not the risk but the near certainty that they will incur attorney's fees fees they will not recover. They also risk incurring a potentially substantial award for their opponent's attorney's fees. The plaintiffs, by contrast, merely face the possibility that they will not be compensated for their own attorney's fees. They run little risk of having to pay their opponent's attorney fees, and to compensate for even this possibility, the private attorney general doctrine permits courts to add a multiplier to the plaintiff's attorney's fees, which can be rewarding. As this case illustrates, the plaintiffs thus have relatively little incentive to settle. Defendants a very strong need to settle. I see no need for the catalyst theory to provide yet more incentive to plaintiffs. For all of these reasons, I would not adopt the catalyst theory as a basis for awarding attorney's fees. I would conclude that before a party can be considered to be a successful or prevailing party under the Code of Civil Procedure, Section 1021.5, or Government Code, Section 12965, subsection B, there must be some court-ordered change in the legal relationship between the plaintiff and the defendant in the plaintiff's favor. Subpart B of the dissenting opinion, titled Plaintiffs Have Not Established Entitlement to Attorney's Fees Even Under the Majority's Catalyst Theory. Even accepting the majority's catalyst theory, plaintiffs have failed to establish entitlement to attorney fees for several reasons. For any plaintiff, including those who actually win their lawsuit, to receive attorney fees, the action must have resulted in the enforcement of an important right affecting the public interest. Code of Civil Procedure 1021.5, a decision which has as its primary effect the vindication of the litigant's personal rights, is not one which brings into play the attorney fee provisions of Code of Civil Procedure, Section 1025.1. In re head is case citation 1986. Plaintiff's complaint was solely for breach of warranty. It sought only class certification, which plaintiffs never obtained, and award of compensatory damages for breach of warranty and attorney fees. This action was at most a vindication of personal rights, not for the important right affecting the public interest. Subsection C, plaintiff should not receive a multiplier for litigating fees on fees. The majority also holds that a plaintiff may recover as attorney fees not only its fees incurred prosecuting the underlying litigation with a multiplier and its fees incurred litigating its entitlement to attorney fees, example, fee on fees, but also a multiplier on fees on fees. I appreciate the majority's attempt to limit the size of such multipliers. The majority's efforts might help reduce the instances of the tail wagging the dog, like here, where the fee for litigating fees on fees is 9 times greater than the fee for litigating the underlying lawsuit, but I would hold that a multiplier is never appropriate for litigating fees on fees. The majority disagrees with courts from other states that have considered this question and tellingly cites no out-of-state cases supporting its conclusion. If, as the majority claims, the private attorney general doctrine is intended to encourage societally useful lawsuits like the majority finds this one to be, and not merely to swell attorneys' coffers, permitting fees for work expended on the actual lawsuit, such a multiplier plus a multiplier, and permitting attorneys to be paid for their efforts in obtaining these fees plus that multiplier is a sufficient incentive. The multiplier on fees generated litigating fees, which as here can make the overall reward truly absurd compared to the effort regarding the underlying litigation, is not necessary. Conclusion. At a time when Californians are increasingly concerned about extortionate lawsuits against businesses, large and small, and worried that the legal climate in California is so unfriendly to businesses that many are leaving the state and others are deterred from coming here in the first place, today's ruling goes in exactly the wrong direction. we should interpret and apply California's private attorney general statute sensibly to encourage responsible litigation while also keeping attorney fee judgments within reasonable bounds and maintaining some semblance of balance between the litigation positions of the plaintiffs and the defendants. Because the majority does not do so, I dissent. I would reverse the judgment of the Court of Appeal. Baxter J. and Brown J. concurred. Now, case notes and questions regarding recovery of attorney's fees. 1. The Code of Civil Procedure, Section 1021. Section 1021 authorizes the parties to a contract to include an agreement as to who will recover attorney's fees in the event of subsequent litigation. Section 1021 is not limited to contract actions. The parties may also agree to recovery of attorney's fees in any tort action which may arise from their underlying transactional relationship. See Palmer and Schaubeck, 1993, Lerner v. Ward, 1993, XUEREB v. Marcus and Millichap, Inc., 1992, Part 2, Civil Code 1717, where a contractual provision makes recovery of attorney's fees available for only one party. Civil Code 1717 makes this right to recover reciprocally binding on and awards attorney fees to the party prevailing on the contract, whether he or she is the party specified in the contract or not. 1717 expressly limits this reciprocal remedy only to an action on a contract or to enforce that contract. The courts have construed this language to preclude application of 1717 to a tort cause of action unless intertwined with a contract cause of action. See example Reynolds Metals Co. v. Alperson in 1979, where a cause of action based on a contract providing for attorney's fees is joined with other causes of action beyond the contract, the prevailing party may recover attorney's fees under Section 1717 only as they relate to the contract action. Lerner v. Ward, Supra. Section 1717 not applicable because plaintiffs dismiss contract cause of action at inception of trial and proceeded only on tort theory that defendant fraudulently induced them to enter real property purchase agreement XUEREB v. Marcus Millichap and Millichap, Inc., 1717, not applicable to action arising out of real estate transaction because plaintiffs submitted their case to jury on negligence and other tort theories and not on the pleaded breach of contract cause of action. Code of Civil Procedure Section 1021.5. The legislature adopted CCP 1021.5 in 1977 as a codification of the private attorney general doctrine developed in prior judicial decisions such as Serrano v. Priest, 1977, see Maria P. v. Riles of 1987. The right to attorney fees under CCP 1021.5 is similar to but independent from the right under the Federal Civil Rights Attorneys Fee Awards Act, Title 42 U.S.C. Section 1988. See Socolo v. County of San Mateo, 1989, comparing prevailing party requirements under the state and federal statutes. Beasley, again, unlike the federal statute, expert witnesses' fees incurred by counsel may be awarded under 1021.5. Now, Section 4, Lodestar Method of Calculating Attorney's Fees Awards. California courts usually follow the Lodestar method when calculating the amount of an award of attorney fees. See Press v. Lucky Stores, Inc., Serrano v. Priest. This method requires the trial court to first determine the lodestar figure by multiplying the time spent on the case by a reasonable hourly rate for each attorney. Once a lodestar figure is determined, the court must consider a variety of other factors which may justify either the augmentation or the diminution of the lodestar amount. Most importantly, for example, the lodestar amount may be reduced, i.e. a negative multiplier, to reflect the relative degree of success achieved by the prevailing party. See Californians Responsible Toxic Management v. Kaiser, which is Kizer, of 1989, which upheld the trial court's 35% fractional multiplier where plaintiff achieved limited success through lawsuit. However, in Graham v. Daimler Chrysler indicates the lodestar amount may also be enhanced i.e., a positive multiplier based on several factors, including the novelty and difficulty of the questions involved and the contingent nature of the fee award. See Beasley v. Wells Fargo, 1991, upholding a increase of attorney fees awarded pursuant to CCP 1021 based on 1.5 multiplier applied to lodestar amount. City of Oakland versus Oakland Raiders. Lodestar amount of $853,000 increased to $2 million. This is subpart 5 under the case notes. Other state statutory authority for an award of attorney fees. Although CCP 1021.5 is the most utilized fee-shifting statute, the California legislature has enacted over 300 other statutes which authorize an award of attorney fees to the prevailing party. See CEB, California Attorney Fee Award, selected California fee-shifting statutes. For a survey of these various statutes by subject, some of the more important of these fee-shifting statutes include Government Code 12965B, Fair Employment and Housing Act authorizes an award of attorney fees to prevailing party in actions brought under the Act. Government Code 800, prevailing party entitled to award of fees in civil action to review administrative proceedings, determination the result of arbitrary or capricious action by government entity or official. Labor Code 218.5, prevailing party shall be awarded attorney fees in action for non-payment of wages or fringe benefits. CCP 1036, inverse condemnation actions. Civil Code 1811.1, 1794, and 2983.4, actions under consumer protection statutes. Civil Code 1942.4b and 1942.5g, tenant actions for breach of habitability or retaliatory eviction, and Family Code 2030 through 2034, attorney fee award in family law cases based on relative circumstances of parties. Now, we are finished the attorney fee subpart B of Chapter 2. There is a subpart C related titled Recovery of Costs by the Prevailing Party. The right of a party to recover costs is purely statutory. Perkos Enterprises, Inc. versus RRNS Enterprises, 1992, and McIntosh versus Crandall, 1941. Set forth below are the relevant statutory provisions governing recovery of costs in general civil actions. California Code of Civil Procedure, 2007, Section 1032, recovery of costs by prevailing party as matter of right. As used in this section, unless the context clearly requires otherwise, complaint includes cross-complaint, defendant includes cross-defendant, or a person against whom the complaint is filed. Defendant includes a cross-complainant or a party who files the complaint and intervention. Prevailing party includes a party with a net monetary recovery, a defendant in whose favor a dismissal is entered, a defendant where neither plaintiff nor defendant obtains any relief, and a defendant as against those plaintiffs who do not recover any relief against a defendant. When any party recovers other than monetary relief and in situations other than as specified, the prevailing party shall be, as determined by the court, and under those circumstances, the court in its discretion may allow costs or not, and if allowed, may apportion costs between the parties or on the same or adverse sides pursuant to rules adopted under Section 1034. B. Except as otherwise expressly provided by statute, a prevailing party is entitled as a matter of right to recover costs in any action or proceeding. Nothing in this section shall prohibit parties from stipulating to alternative procedures for awarding costs in the litigation pursuant to rules adopted under Section 1034. Section 1033.5, items allowable as costs. A. The following items are allowable as costs under Section 1032. 1. Filing motion and jury fees. 2. Juror food and lodging while they are kept together during trial and after the jury retires for deliberation. 3. Taking, videotaping, and transcribing necessary depositions, including an original and one copy of those taken by the claimant and one copy of the depositions taken by the party against whom costs are allowed, and travel expenses to attend deposition. Service of process by a public officer, registered process service or server, or other means, 5. Expenses of attachment, including keeper's fees. 6. Premiums on necessary surety bonds. 7. Ordinary witness fees pursuant to Section 68093 of the Government Code. 8. Fees of expert witnesses ordered by the court. 9. Transcripts of court proceedings ordered by the court. 10. Attorney fees when authorized by any of the following: contract, statute, and law. 11. Court reporters' fees as established by statute. 12. Models and blow-ups of exhibits and photocopies of exhibits may be allowed if they are reasonably helpful to aid the trier of fact. 13. Any other item that is required to be awarded to the prevailing party pursuant to statute as an incident to prevailing in the action at trial or on appeal. The following items are not allowable as costs except when expressly authorized by law: fees of experts not ordered by the court, investigation expenses in preparing the case for trial, postage, telephone, and photocopying charges except for exhibits. 4. Costs and investigation of jurors or in preparation for voir dire. 5. Transcripts of court proceedings not ordered by the court. And C. Any award of costs shall be subject to the following: 1. Costs are allowable if incurred, whether or not paid. 2. Allowable costs shall be reasonably necessary to the conduct of the litigation rather than merely convenient or beneficial to its preparation. 3. Allowable costs shall be reasonable in amount. And 4. Items not mentioned in this section and items assessed upon application may be allowed or denied in the court's discretion. So there's case notes to the recovery of costs, which are fivefold. 1. Allowable costs. A prevailing party is entitled to recover costs as a matter of right. CCP 1021, 1032B, Section 33.5A specifies those items generally recoverable as costs of right. Section 1033.5B specifies those costs not recoverable unless expressly authorized by law. An item not specifically allowable under 1033.5A nor prohibited under 1033.5B may nevertheless be recoverable in the discretion of the court. CCP Section 1033.5C4. 2. Prevailing party under CCP 1032. Section 1032A clearly defines who is the prevailing party in a variety of typical situations. The proper interpretation of these statutory definitions is not so clear. However, in less typical applications, in McLaren, Vasquez and Partners, Inc. versus Downey Savings and Loan Association, 1991, for example, a plaintiff filed a complaint seeking damages against the defendant for breach of contract and tortious denial of contract. The defendant cross-complained against the plaintiff seeking damages for breach of contract, negligence, and related claims. Following a jury trial, general verdicts denying relief to both parties were entered. Is the defendant the only prevailing party pursuant to Section 1032A4, or are both parties prevailing parties under Section 1032A1 through 4 and both entitled to an award of costs because the defendant filed a cross-complaint against the plaintiff and neither party was successful on its action? It is 1032A2, which defines a defendant to include a cross-defendant of any relevance to this issue. The court in McLaren held that both parties were denied relief on their respective claims. The defendant is entitled to an award of costs, but the plaintiff is not. The court rejected an interpretation of 1032, which would make both parties prevailing parties and therefore both entitled to the award of costs, commenting that the practical effect of such a result would be to conclude the prevailing party is the one who spends the most. What does the court mean by this comment? Do you agree with the McLaren court's interpretation of 1032 and why? Yes. Procedures. The procedures for claiming and for contesting costs are set forth in Rule 3.1700 of the California Rules of Court. A prevailing party who claims costs must serve and file a memorandum of costs within the time specified in the rule, usually 15 days after entry of judgment. Any motion to strike or to tax costs must be served and filed within an equally short period of time. 4. Costs must be reasonably necessary. Costs that are allowable as a matter of right or as a matter of discretion must be reasonable in amount and must be reasonably necessary to conduct the litigation rather than merely convenient to or beneficial to its preparation. CCP 1033.5C2 and 3. Technological advances in the conduct of litigation have complicated the reasonably necessary determination. See Science Applications International Court v. Superior Court of 1995, finding expenses incurred for the graphics communication system and for editing of videotape depositions for effective presentation of testimony to the jury were not reasonably necessary. 5. Effective statutory offers to comprise on recovery of costs, the costs allowed under CCP 1032 may be withheld or augmented pursuant to CCP Section 998. Section 998 authorizes a party to serve upon any other party a written offer to allow judgment to be taken in accordance with the terms and conditions stated in the offer. If an offer made by the defendant is not accepted and the plaintiff fails to obtain a more favorable judgment, the plaintiff shall not recover his or her post-offer costs and shall pay the defendant's costs from the time of the offer. Section 998C. If an offer made by a plaintiff is not accepted and the defendant fails to obtain a more favorable judgment, the court, in its discretion, may require a defendant to pay a reasonable sum to cover the costs of the services of expert witnesses in addition to plaintiff's costs. And that's going to conclude Chapter 3. That was titled Statutes of Limitations, Attorney Fees, Court Costs, and Related Matters.